everyone. We're going to discuss Chapter 35, and that is Major Forms of Business Organizations for Business Law 2. I'm going to quickly talk about the types of partnerships that exist. The first one that I'm going to talk about is the general partnership. This is a partnership in which the partners equally divide the profits and the management responsibilities, and they also share in unlimited personal liability for the partnership's debts. Then you have the limited partnership. This is a partnership that is consisting of one general partner and at least one limited partner who does not have any part in the management of the business. You also have the limited liability partnership, in which all partners are liable only to the extent of the partnership's assets. However, in this business formation, the partners are partaking in the management of the business, unlike the limited partnership, where you would have the general partner who is managing the business and the limited partner who's merely investing the capital. You also have the cooperative, which is a business organization consisting of individuals who join together to gain an advantage in the market that mutually benefits all members, and they can be incorporated or unincorporated. There's then the joint venture. This is a relationship between two or more persons or corporations that is created for a specific business undertaking. Now I'm going to talk about some specialized forms of business organizations. First, let's talk about the cooperative. This is a non-profit organization in which members pool their resources to gain some type of an advantage in the market. Then you have a joint stock company. This is a mixture of a partnership and a corporation. There's a syndicate, which is an investment group that comes together to finance a specific large product. There is a joint venture, which is created for a specific undertaking and includes financing, producing goods, selling goods, securities, and commodities. There's a franchise, which provides a strong trade name or trademark of a franchisor. This will bring customers to the franchisee. There is also a franchise agreement with that franchise, and this typically outlines the payment, the location, business practices and agreements, prices, and how and when the franchise relationship may be terminated. In the next slide, I'll be discussing Myers versus Christie, and this will consider the formalities involved in a joint venture. Here I am going to briefly discuss the Myers versus Christie case. The facts are as follows. David Christie and Alexander Glenn entered into an oral joint venture agreement with Alan Mayer and John Pratt to purchase and manage an area for residential housing. A few weeks later, Christie and Glenn terminated their relationship with Mayer and Pratt, forming another corporation with two other individuals. Mayer and Pratt then subsequently filed a claim for a breach of the joint venture, as well as several other claims. The issue before the court was, did the defendants breach a joint venture agreement with the plaintiffs? The history of this case is as follows. The jury found in favor of Mayer and Pratt, the plaintiffs. The defendant then appealed, asserting lack of evidence of the joint venture. Then the higher court affirmed in favor of the plaintiffs once this case was appealed. The reasoning behind the court was as follows. The court was not persuaded by the defendant's argument that a joint venture did not exist because there was ample evidence that the defendants and the plaintiffs had agreed to commit to a joint venture, and because the formation of the joint venture agreement was already taking place. Further, the court held that the statute of frauds does not bar the plaintiff's claim or limit their potential damages because the statute applies only to purchase agreements between the seller and a buyer. The evidence makes a persuasive case that the joint venture is enforceable. Now I'm going to cover Mary Kay versus Janet Isbell. This case considers whether a franchise agreement exists between the parties. The facts are as follows. The defendant terminated its agreement with Isbell. Isbell then filed suit against Mary Kay, wherein she claimed that Mary Kay had violated the Franchise Practices Act. The procedural history of this case is as follows. The trial court ruled as a matter of law that Mary Kay's termination of Isbell had violated the act, and the jury then awarded Isbell damages. However, Mary Kay then appealed and won because the court held that Mary Kay was not a franchise within the protection of the Arkansas Franchise Practices Act. The reasoning behind the court is as follows. The plaintiff was not permitted to sell Mary Kay services, and she never showed that she sold Mary Kay services. The agreement between the defendant and the plaintiff did not contemplate the establishment of a fixed location for the display of sale products. The business relationship between Mary Kay and Isbell was not a franchise within the protection of the Arkansas Franchise Practices Act. This, of course, would vary amongst state to state depending on their statutory law. The next case I'm going to discuss is Patterson versus Domino's Pizza. This case is going to examine whether a franchisor can be held vicariously liable for the actions of a franchisee's employees. The facts are as follows. In 2009, Taylor Patterson alleged that she had experienced sexual harassment from her manager while working at a Domino's franchise. Taylor eventually resigned her position and sued her manager, the franchise, and the Domino's Corporation. The Domino's Corporation asserted that they could not be held vicariously liable for the harassment because Domino's was not Patterson's employer or principal. Domino's then argued that the franchise was a separate business that selected and managed its own employees. The issue before the court was as follows. Was the Domino's Corporation Patterson's employer, which would make it vicariously liable? The procedural history of the case is as follows. The district court ruled in favor of Domino's, but the appeals court then reversed for Patterson. The holding of the Supreme Court of California was as follows. They reversed in favor of Domino's. The reasoning was the franchise agreement between Domino's and the franchise claimed Domino's responsibility for the franchise employment matters and stated that there was no principal-agent relationship between the two. The franchise established its own anti-harassment training and managed the day-to-day conduct of employees. Even if Domino's knew about the harassment and wanted to discipline franchise employees, they had no authority to do so under the agreement. The employees in question were employees of the franchisee and not Domino's. Here I'm just going to add some additional clarification on business formations that we've already discussed. The general partnership is one in which two or more partners divide up the profits. This is usually equally, as well as the management responsibilities, and they share unlimited personal liability for partnership debts. Then you have the limited partnership, which is one general partner and one limited partner. The general partners share unlimited personal liability for the debts of the partnership, whereas the limited partners have no liability beyond the capital they have invested. Limited partners also share in none of the management of the partnership, but they do have to pay taxes on their portion of the profits. In a general partnership, the death of one of the members dissolves the partnership, whereas in a limited partnership, the death of a limited member does not affect the partnership, but the death of a general partner will dissolve the partnership. A general partnership technically does not require any special paperwork, but a limited partnership does require that there be a name designated to the business as well as a certificate of partnership be filed with that state. Here I'm just going to continue about some various business formations. Let's start with the cooperative. These are organizations which are formed by individuals in order to market products. A cooperative is a not for profit organization in which members pool resources together in order to gain a market advantage. Then you have the dividends of these cooperatives, which are paid to the members in proportion to how many times per year they engage in business with the cooperative. There's also syndicates. These are an investment group that come together for the explicit purpose of financing a large product. Syndicates are often utilized to raise large amounts of money in a small amount of time, whereas cooperatives cannot claim to be a syndicate because cooperatives are for nonprofit and the syndicates are intended to raise large sums of money. Franchise agreements are usually they're stated how much the franchisee will pay to the franchisor for the use of the trademark or the trade name. The agreement will also include where the franchise is to be located, and it will outline the prescribed business practices and the standards which are expected within that business model. The agreement will also outline how the franchise would be terminated.